Are games patentable? Specifically, are game mechanics patentable? For example, could someone patent a sanity system for a video game, one in which a player character's mental health is incorporated into the game in much the same way as a player character's physical health, as in a game like Nintendo's Eternal Darkness? That's the topic for this episode of Games Are Not Coffee Mugs. Welcome to this edition of Games Are Not Coffee Mugs. The topic today is the patentability of games and game mechanics. My guest is Professor Benjamin Liu of the John Marshall Law School. Professor Liu graduated from UCLA in 2004. After law school, he went on to practice for Strug, and Levon, primarily practicing patent law. He's one of my colleagues now here at the John Marshall Law School. Thank you very much for joining me today.
Thank you for having me.
35 UIC 101 tells us that whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof may obtain a patent thereof, subject to the conditions and requirements of this title. So let's start with the first requirement laid out in section 101,
Sure.
and that's the utility requirement. Do games satisfy the utility requirement?
Well, at this point in the United States jurisprudence, it's not a controversial question. Games and the implementations used to play games are pretty much recognized by courts as satisfying the utility requirement under 35 USC 101. There were earlier cases dated back to the 40s even, suggesting that tools such as gaming tables for playing card games or whatnot are useful articles in light of the industry, the amount of interest our society has in these games, and culturally the role games play in our lives. And therefore, games are useful.
Now, I do know that the Patent Office has granted patents going back even to the 19th century.
Sure.
So it doesn't appear that this has ever been a particularly controversial question, except insofar as games might be related to gambling activities.
Sure. And I mean, historically, there is a strand of patent law that disfavors immoral activities. But even that has gone away subsequent to such a key case, what's known as the Juicy Whip case, involving a juice vending machine that may involve falsely advertising the source of the juice. And there, the court had said, even though the purpose...
The Federal Circuit.
Right, the Federal Circuit had said, even though the purpose of the machine might have been one of deception, or to mislead consumers. Nonetheless, it serves a purpose for the businesses to maybe attract more customers, and therefore it is useful in that sense. And gaming machines as being patentable and is currently patentable without question.
Now, you pointed out to me that some jurisdictions won't grant patents to games. Germany, for example.
Sure, yes.
So Germany actually has a provision that explicitly says schemes, rules, and methods for performing mental acts, playing games, or doing business, as well as programs for computers, are excluded from the subject matter of the German patent law. Is the thinking there, if you know, whether or not games are seen as failing the utility requirement, or is it seen as something that doesn't, an area that doesn't benefit from the incentives provided by patent law? Or perhaps there are other practical problems with granting patents to games that may have motivated that provision?
Sure. That's a provision that's not only unique to German patent law, but you also find it in, for example, Chinese patent law. And I think it's not that difficult to comprehend in terms of it does find echo even in our current jurisprudence along the lines of exceptions to patentable subject matter. Even in the United States, we carve out mental processes, abstract ideas, and this is in our Supreme Court jurisprudence as well. And therefore, I think the position Germany adopted is more of an extension along those lines, denying patents to what's considered natural law, what's considered abstract ideas. And although rules of games may seem concrete and detailed enough in some sense, it's not generalized law of gravity that's often invoked in these discussions. Nonetheless, in Germany, it's still considered a pure mental exercise and therefore not eligible for patent protection.
Okay, well, let's turn to the various categories of patents enumerated in 101.
Sure.
Which of the Section 101 categories are games and game mechanics in? Are they processes, machines, manufacturers, or, this seems unlikely,
sure,
compositions of matter?
Sure.
And the reason why I ask is I wonder if it might be important for purposes of the Supreme Court's decision in Bilski if we think of games and game mechanics as patents about processes or manufacturers. If they're patents about processes, then there is at least a potential problem with obtaining a patent because the Supreme Court said that even though the machine or transformation test is not the sole basis for deciding when a process is patent eligible, it's still a significant part of the inquiry. So to the extent game mechanics may not be clearly tied up with a particular machine, they may not be patent eligible if game mechanics are in the process category.
Right, and that's definitely a concern. And games are, I think it could be in the category of a manufacturer, right? It definitely, some aspect of it could definitely be in the category of processes. And in fact, you can take the same game and probably obtain independent claims covering, characterizing the game in each of these different ways, just by ways of patent claim draftsmanship, right? And then it brings on the question of, well, does that run afoul of Bilski? And that it actually, we come full circle and it echoes the concern of, for example, the German patent law. How is it too abstract the way you draft the claim or not?
Well, suppose a patent examiner objected to a particular claim on the ground that it's a process claim and it's not tied to a machine and it doesn't involve a transformation of matter from one state to another. Could you overcome that objection merely by adding dice or a board to the claim?
Well, this is actually a challenging question currently, and it's and in the context of, does adding a computer to these softwares or algorithms of which game mechanics could possibly be a subset of, right? Whether adding a generalized computer to these processes would bring these abstract processes into the realm of patentable subject matter, and this is an area of debate among courts. And I would my suggestion when it comes to dice and board is that if the use of the dice and the board is sufficiently integrated with the mechanics of the game, such that it forms an integral part, then you have a higher chance of it being patentable or satisfying the patentability requirement.
Well, it seems strange if a particular process that is originally intended to work with board games could suddenly become patent eligible because the applicant says, well, just do it in video game form. Add a computer. Right. Obviously, most board games can be translated into a video game form, and many video games can be translated into some sort of board game form. is that is that sort of distinction likely to be decisive if you say, well, take my board game
sure.
idea and just do a video game version
I
to
th-
solve the objection?
I think the larger motivating factor behind patentable subject matter is articulated under a different line of cases, Diamond versus Chakrabarty, where the Supreme Court famously said, anything under the sun made by man is patentable. This is designed to be a coarse screen, right? And as to whether or not previously known gameplay rules is patentable now that it's implemented on computers, might sometimes be better addressed under inquiries such as under rules 102 or 103 of our.
Well, I'm not talking about a situation
rules.
now where somebody is trying to claim a previously known gameplay mechanic, and the only change is that it's now to be embodied in video game form. I'm wondering about the situation where the patent office objects to a particular gameplay process, and whether or not you can overcome that objection by just saying, add a video game computer, add a console, add a PC, and if that will then be enough to satisfy any Bilski-related concerns, because now there's a machine.
And I think that it's becoming more difficult, actually. In the most recent case on this issue, CLS Bank versus Alice, the opinion just came out a few days ago. It's an en banc Federal Circuit case where the judges in heavily divided opinions denied patent eligibility to a set of financial hedging processes, even though these processes recite the use of computer processor and processes. And some see this as extension of Bilski, in which a naked hedging mental process untethered to any technical implementation was denied patent eligibility by the Supreme Court. So now it seems to be that even a formulaic recital of computer or computer processors or computer readable medium are no longer enough to bring an otherwise ineligible process into the realm of patent eligibility.
I take it that although the shorthand formulation from the Bilski decision is machine or transformation, that the Supreme Court actually said machine or apparatus. And so it's not just a computer that might be the machine at issue. It could also be an apparatus in the form of dice. So you'd have the same question if adding dice can overcome the concern reflected in this recent decision.
The analysis would be, I think the analysis would be identical.
Okay.
It's a question, and I think this is a gray area where reasonable judges could differ.
Okay. Yeah. Well, let's turn to the barriers to patentability, and we'll start with novelty. Briefly, what's the novelty barrier?
Well, technically, under 35 UIC Section 102, in order to obtain a patent, your invention has to be novel, which means that it has never been described in the past. And technically, when we conduct the novelty analysis under patent law, what we do is we take the claim as written, we break it down into the elements, and we try to construe the meaning of these claim terms and what they mean altogether in the process referred to as claim construction. And then compare that to what has previously been known, described, or being used in order to decide whether what you're claiming today is novel vis-a-vis that which had been known in the past.
And novelty is the more easily overcome hurdle because we need a single prior art reference to describe all the elements of the claims.
Yes, and really you're looking at the identity of the claim language to anything that comes before it. As long as there's any difference, your invention will be considered novel.
All right, so the more interesting inquiry or the more important inquiry most of the time is going to be obviousness under Section 103. So briefly, what's the obviousness inquiry about?
So whereas 102 or novelty is concerned purely with whether or not these disclosed ideas and your invention are identical, the obviousness under 35 U.S.C. 103 looks at any existing difference and asks, does a person of ordinary skill in the art, in the field of technology that your invention pertains to, would be able to bridge the gap, would be able to modify or combine pre-existing knowledge into the invention that you're presenting today.
Okay. And as part of the inquiry, the Supreme Court has said that there are these secondary considerations to take into account as part of the obviousness analysis. Commercial success, long felt but unsolved needs, and a failure of others to resolve a particular problem. Now, when we're talking about the game context, it's not clear how at least the second and third should work, because we don't ordinarily think of technical problems of game mechanics. There may be technical problems associated with putting an image on a screen, but when it comes to gameplay mechanics, it's a little odd to talk about unsolved problems. And the only example I could come up with where there's perhaps this unsolved problem recognized in the gameplay literature would be the problem of simulating the fog of war in war games. And the obvious problem is that if you're playing a board war game and you can see everything on the table, you have a view that is much different than the view that an actual participant in the battle or conflict would have had. You can see all of your units perfectly, you can see all of your opponent's units perfectly. You have perfect information when you can see everything on the board like that. And to the extent these games attempt to offer some kind of realistic simulation, to the extent you can in a board game, that's a problem. And so the question was how to overcome it. So various methods of dealing with that problem have cropped up over the years. So for example, in hex and counter war games where you have these little tiny cardboard pieces on the board, one solution was to put a piece on the top that has a question mark on it, which makes it unclear what pieces are below it, and that designates it as one that your opponent can't look through and thumb through to see what's there. And the stack might be nothing but question mark counters. In other words, it would throw off your opponent into thinking there's something there when there isn't. So that's one way of dealing with it. Another way is, much like the game of Stratego, to have pieces on blocks, as many games from one particular company have done over the years. Put the pieces on blocks, and then only you can see what the particular units are. So that may be an example of a technical problem that game designers have tried to overcome. But I'm hard-pressed to come up with very many of those. So to the extent these secondary considerations may be misfiring here, does that tell us anything about whether or not we ought to be patenting game mechanics at all?
Well, I think it does have challenges fitting into some of the doctrinal contours. I would, though, broaden out your suggestions to this fog of war situation, to any situation where a game may be called on to simulate something. There are other games that looks to include rules that on how, for example, whether might affect a battle outcome, right? So then one can frame a question: how does a set of game mechanics or game rules take into account of simulated weather onto this game? Right? Another situation where it may arise is, I'm sure all of us who plays games sometimes would be engaged with a particular mechanic, but wish in the back of our head that wouldn't it be better if we can change something so that, for example, if someone is losing early in the game, they might still have a chance of coming back at a later part of the game in order to keep everyone engaged in the game, right? And I think there are problems, so to speak, of enjoyment that we may uncover as we play a game that can still allow for tweaking and improvement that may satisfy what you framed as solving a problem. Now, but taking a broader view, I agree with you that games are largely creatures of our own imagination and amusement. It's not really something that's designed to solve a standing problem. But in some ways, there may be it doesn't necessarily undermine their inventiveness or non-obviousness, because in some ways, something that emerges out of someone's mind, sui generis, right, may in some ways be considered more non-obvious if there were no problems to be solved, and yet a creative mind can create this set of rules whole cloth just for the purpose of entertainment. Maybe that actually speaks to additional non-obviousness too. So depends on how you cut it.
Let's pursue the obvious inquiry in a little bit more detail using an example. The example I'd like to use is one called Sanity System for a Video Game. This is a patent that was assigned to Nintendo of America. It was issued on August 30th, 2005. Now, we're not going to be able to go through all the claims in the patent, but let's talk about some of the key claims here. So the first claim basically says the following. At the beginning of the game, we are going to set a sanity level for a character, much like we would set a number of health points for a character. We'll set a sanity score for the player. During the play of the game, that sanity level will be modified. Things can cause the number to go up or down depending on what happens in the game. And as the sanity level changes, in-game consequences will occur. So, as an example, Dependent Claim 2 says that if you encounter a game creature or a gruesome situation, your sanity level can go down. Dependent Claim 7 says that if your sanity goes down, you may start to hallucinate. And as described elsewhere in the patent, you may start to see things in the game that even in the game aren't supposed to be there.
Right.
Things will appear on screen, voices will be heard on screen, but they're not supposed to be there. It's supposed to represent an hallucination. So what's interesting about this particular patent is that although this particular gameplay mechanic is described as a new gameplay feature for video games, such as role-playing games, you can actually trace a very similar system back to older games like the Call of Cthulhu, a pen and paper role-playing game that came out in 1981. And so I'm interested in your take on these claims, given some of the prior art that can easily be found, prior art that wasn't cited in this particular patent. So here's one example. This one actually predates even the Call of Cthulhu game. This is a magazine called Different Worlds. It's issue number 6. The date on it is December, January 1980. One of the articles in here is called Insanity Table. Now, it's a very short article. It has only a paragraph saying that this particular table could be used for Dungeons and Dragons. It's left up to the game master or dungeon master to decide when to use the table, but what the table provides is a set of consequences that may occur when a character goes insane. For example, you roll a D100, and if you roll a 14 to 19, the consequence is hallucinations. Sees or hears things that aren't actually happening and cannot be convinced that he is hallucinating. It sounds to me like this is highly relevant prior art. It sounds to me like it would be analogous prior art given what the Federal Circuit has said in interventions in other cases.
Definitely.
Would the particular claim that I mentioned to you be obvious based on that piece of prior art? I'm thinking of the claim that talks about hallucinations as being a consequence.
I think especially after the case such as KSR. Well, I think that this is definitely relevant for obviousness analysis of the set of claims you presented. But there are significant differences.
Between the patent claims and what I just described?
Yes, because the most obvious differences being one is in the pen and paper context and one is in the video game context.
Well, there's also no setting of a sanity level in that particular article. Again, it's just left up to the referee, the game master, the dungeon master to decide for some reason a player character has gone in saying, now I'll roll on the table and see what's happened. So that's clearly a difference. The first claim in this patent talks about setting a sanity level. That doesn't happen in the article.
But certainly you can probably find other prior art.
Oh, indeed you can. Indeed you can. So if we turn to Call of Cthulhu, then we get some additional prior art that's relevant. Now this copy I have here is the second edition.
Sure.
This is actually a legitimate copy that I purchased on a website that sells out-of-print role-playing game books in PDF form. I don't have the first edition though. But in this particular game, which expands to a much greater extent on the use of sanity in a role-playing game, in this particular game, you do set a sanity level at the beginning.
Yes.
Your sanity level is based on another ability score, and you multiply that ability score times 5. So that other ability score is called power. This is a measure of a person's charisma, soul, or will. So you start with that number. The way you get that number is you roll 3 6-sided dice, so 3 to 18. Sanity is actually 5 times the power score. That's your initial starting level. It's adjusted throughout the game. Now, what causes sanity to be adjusted? Well, if you see one of the Cthulhu mythos creatures, that can cause your sanity level to go down. But it's not just seeing monsters, although seeing monsters or game creatures was mentioned in claim number 2.
Sure,
But it can also include being surprised by a corpse, being surprised by a mangled corpse of an animal, surprised by a fragment of a corpse.
I would go insane, sure.
Gruesome situations are defined or described in claim number 2. Gruesome situations are described as affecting your sanity here in the Call of Cthulhu game. It looks like this should cover the very first claim that I mentioned. It looks like this should cover the second claim that I mentioned. This particular article should cover the other one that I mentioned, which is actually claim 7 in the patent. What's your take on how we would deal with this prior art that's sounding awfully similar to what's going on in this Nintendo patent?
Patent examiner would definitely find this relevant information because it's describing the key mechanics. Even if it's in the pen and paper version, it still informs the underlying idea, right, of playing a game or modifying behaviors or the game environment based on this insanity score. Now, having said that, it's probably it's the patent did issue, and then this was also the time before KSR, where in order to combine references and make to reach obviousness conclusion or inquiry, you may need certain teaching, suggestion, or motivation that's explicit. Now that's no longer the
teaching,
case.
suggestion, or motivation to combine particular prior art elements.
Or if it's a single art, to make that extension and bridging the gap between.
This magazine is actually a role-playing magazine.
Sure.
This is a role-playing game.
Sure.
It seems like there would be a strong motivation to use these 2 particular pieces of prior art.
And these are
come up with a sanity system that may cause you to hallucinate as one effect. There are others.
Right. And one would say that a person of ordinary skill in the video game industry would look to pen and paper predecessors, prior examples for inspirations, for ideas. It definitely speaks to that. And now in the post-KSR world, I mean, that argument is only stronger.
So the filing date on this particular patent was 2000. Do you think there is a difference between the present and 2000 in terms of how we might look at this prior art?
Sure.
Would an examiner have potentially thought about it differently in 2000 if the examiner had been aware of this prior art?
If the examiners have been aware of these prior arts, still, the year 2000 when this patent was filed, and that's the point in time where patent examination is based on. There's still a question of how easy it is to translate a certain pen and paper mechanics or effect into a game world. It's a technical issue where not so long ago even, games were rendered in 2 dimensions, right? Even though nowadays everything appears in 3D, and it took considerable effort, right? In the early days of the gaming industry, in order to figure out how to transform a game world from a flat, overhead 2-dimensional place to 3-dimension. So,
now, this particular patent, though, is not about the technology for portraying, say, the hallucination.
Right.
It's simply saying there'll be an hallucination.
Right.
It's up to the programmer to figure out how to implement that.
Exactly, yes. And so maybe it's, in light of these prior art, it may be difficult to obtain a patent where your game is simply displaying the word, you are now insane, or in the text somewhere, you are hearing hallucination in the old text adventure style. But
wouldn't it be obvious that if you were going to have a character go insane in a game and hallucinate, that you would visually depict it rather than just say it in the way that you might have for an old text adventure?
Sure, Zork.
A Zork-like text adventure might just say you've gone insane.
You've gone insane, exactly.
Or it might say you're imagining that you see a ghost or something.
Right, exactly.
But it seems fairly obvious at this point that if you're going to portray insanity in a graphically based game, that you would show some imagery.
In 2013, yes.
You don't think so in 2000, though?
And so that's a question of I think the examiner would have to revisit at that point in time how easy or difficult or intuitive or obvious it is for a game designer to try to implement that visually. It may be already a given at that point. Then I'm with you.
Okay.
But it could also be the world of Doom wasn't even that long before then, right?
1993.
93, right.
December 10th, 1993.
Right.
Even if we can't resolve the question right now about whether or not this particular patent should be invalid for obviousness, it seems clear that these various prior art references should have been considered.
Definitely.
And it's not just these two. This particular issue of Different Worlds has another article on insanity. Supplements to the Call of Cthulhu game go into more detail on insanity. This one's called Taint of Madness. It also predates the patent application by many years. I think GURPS Horror is probably relevant prior art, although it describes things in terms of fright checks instead of sanity checks, at least in this particular book. So my question is this: should we be worried about the Patent Office's competency with this particular art? If the Patent Office didn't find any of this, including Call of Cthulhu, which is a fairly well-known role-playing game to those who are interested in the art of games. It's not an obscure game.
Right.
If the Patent Office is missing things like that, and I understand this is just one patent, perhaps they hit it out of the park 99% of the time, and this was one where the Patent Office potentially missed relevant prior art. But I think it's a plausible worry that the Patent Office is going to lack the expertise to really identify relevant prior art.
That I agree with you completely. And regardless of whether or not this patent would have issued, knowing these prior art references, I think that it had the Patent Office knowledge of these game mechanics earlier. Even if they issued the claims, it would have been much narrower and probably directed more towards the technical aspect of how to actually implement it in that specific game, instead of a general prescription on insanity meter. So not only does that have an effect on whether or not patent would issue, it would also have an effect on how broad or narrow the issued patent ultimately becomes. Now, I think the reason why it's particularly challenging for patent office is, I think there are actually multiple reasons. One, the first is this is, or at least at one point in time, this is not a well documented art. It may exist in player books, it may exist in other written forms, in magazines, in fan magazines, but that may not be the type of things that the patent office has a ready collections of or in their database.
I'm sure that's right. And that's potentially part of the problem that the patent office is going to be examining.
To index, they don't
patents
index
related to game mechanics.
Right.
They don't have these materials. In fact, many libraries wouldn't even have these materials.
Now it's a lot better now that internet search has become so powerful, and a lot of the older publications are now available online, put up there by fan or by interested players who are interested in the history of gaming. So maybe patent examiners can uncover them in this way. But even if they have access to this broader set of database, there's another problem, which is what do you search by? A lot of these game mechanics use conventional words. This is not a case of a chemical or biological molecule, where if you type in a very specialized scientific name of something, it will pull up highly relevant prior art, where what you're looking for is pretty much there right away. If you type in words such as insanity, role-playing, dice roll, I mean, can you imagine what a vast, what a vast number of false positives the hits may turn up, and then the examiner would have to sieve through all of these false positives in order to find those documents that actually talks about the insanity meter. So that's another challenge. Linguistically, it's hard to search these game mechanics.
I think that would likely apply to a good number of game mechanics. This particular one, I think, should be easier because sanity is one of the core features of the Call of Cthulhu game. So for this particular example, it might be easier to find the relevant prior art. But I agree, for many other games, it may be tougher because the particular mechanic may not be core to the game. And just Googling role-playing sanity system, I suspect, pulls up something related to
But in this case, you run the risk of false negatives. In case where Cthulhu luckily used the word insanity. But one could easily imagine previously known mechanics that describes themselves using words such as madness meter, craziness meter. In which case, if you use the word insanity, you would actually miss those, right? So again, if you're searching in an art that relies on common, ordinary words, you have to worry about, things that's picked up that doesn't relate to you, as well as maybe missing, synonyms that you should have searched by. So this is a tough area to search. And then finally, who is to have expertise in these, right? When patent examiners are invited to join the patent office, or I guess apply to the patent office for a job, they have to show they have a technical background in one of the biological science, physical science, engineering, electrical engineering. Unfortunately, game design isn't exactly one of the background that the patent office select for.
Well, I suppose one solution would be that the patent office hire gamers, although a different solution would be to follow the German model and not issue patents for gameplay mechanics. So what's your take on this question? Should we be patenting these things at all? Because my intuition is that we don't need the patent system to provide an incentive for the creation of game mechanics. I don't think it's remotely close to some of these other areas where the incentive is probably fairly critical because the research costs are enormous and the costs of copying are very low. Here, the cost of copying mechanics are very low,
Sure.
but I don't think the cost is particularly high for developing gameplay mechanics. And so the German model seems to have some appeal here. What's your take on this?
I'm not adverse to that, and I think that, and part of it is, I do think that many games have components that enjoy robust copyright protection. Game books, maps, game boards, and even game pieces would often qualify for copyright protection. And if you're talking about video games, certainly the visuals and even the source code are subjects of copyright. So query whether we need broad patent protection for underlying rules and mechanics. If the game itself enjoys copyright and we can prevent others from simply cloning or copying a game that way.
Okay, well, I think you're right. I think there are plenty of elements to games that are subject to copyright protection, but I also think that courts have actually been willing to protect even gameplay mechanics under the Copyright Act. So 102B says processes aren't protectable. The Copyright Office has taken the position that methods of playing games aren't copyrightable. Right. But I think if you look at the video game cases, for example, the Midway versus Arctic case involving the Galaxian game and a speed-up kit that you put onto the Galaxian motherboard. It's a small board that you plug in to the Galaxian motherboard. If you do that, it speeds up the game.
Right.
The court said that speeding up the game creates a derivative work, an infringing derivative work, even though arguably all it does is speed up an unprotectable process. And more recently, we have the Tetris decision in which the court said that you're free to make games with other pieces, but you're not free to make a game with the same pieces that move in the same way as the Tetris pieces.
Right.
And those movements of the pieces and the shape of the pieces in that particular game, I think, are all gameplay mechanics. Contrast that with, say, the artwork in Galaxian. So Galaxian, you have little spaceships that fly down, somewhat like Space Invaders. The particular way in which those spaceships are drawn is surely subject to copyright protection. You could draw them in different ways and still be playing the same game with the same process, with the same game mechanics. But the court was willing to protect even the gameplay mechanics. And my hunch is that at least when we're talking about video games and an audiovisual work, courts are going to view them more like they would films and discount the process problem raised by 102B, although it potentially means that game mechanics are eligible both for patent protection and copyright protection.
I think there is a problem of generality, the level of abstraction and generality you're working with. If you're trying to go with this dichotomy of what's game mechanics, how does that fit within the schema of idea expression using copyright parlance, or the idea of what's a patentable concept versus what's a copyrightable expression.
But I think that's part of the problem, to frame it as a question about idea and expression. The word idea connotes a very high level of abstraction. When we're talking about processes or methods of playing a game, those can be fairly detailed. And so courts, of course, use the word idea in 102B as a shorthand for everything else on the list in 102B, but not everything on the list is equivalent, I think, to the word idea. So you're right. If you think of gameplay processes as just ideas, then you could have the idea of ships attacking a smaller another ship at the bottom. You could show that in many different ways or depict it in many different ways. But if we're actually interested in the process of Galaxian as a gameplay mechanic that's potentially eligible for patent protection, then it would include the precise way in which those shapes move on the screen. And those shapes could be depicted in different ways. I'm thinking about Galaxian. Now with Tetris, The elements that I think are clearly eligible for copyright protection would be the background imagery that is included with some versions of Tetris. Music, of course, would be eligible for copyright protection. But that's a game where the simple shapes are really all that there is to the gameplay, the simple shapes and how they move. So I think we have a merger, so to speak, between the expression and the process.
Right.
But courts resist that conclusion because they resist saying that somebody can make a precise copy of Tetris's gameplay. Set aside the music, set aside background imagery. You could also illustrate the little blocks with different patterns inside the blocks, different textures. But they don't want people to be able to copy even the basic gameplay mechanics. So the courts, concerned about copying, will put the elements of Tetris that I think are really gameplay mechanics into the category of a visual display.
Now, if the game had involved Tetris pieces that doesn't exist, shapes that doesn't actually exist in Tetris, which way do you think the court would go?
Well, the court said you could do a game with different shapes in the Tetris case. But then I'm not sure you're playing Tetris anymore if it's a game with very different shapes.
So in other words, we're going back to the question of what is Tetris, right? What is the mechanic that defines Tetris? Because you can imagine everything else being the same, but instead of having, the pieces that they give you, you can have, for example, 4 1-by-1 blocks arranged in a crisscross pattern with a hole in the middle. That's a piece that doesn't exist in Tetris, right? But the court seems to be receptive to a game that's made out of those a piece of that shape, even if everything else, every other rule is followed, right? So I think that.
Well, but it did talk about protecting movement. The court did talk about protecting movement.
Yes.
I'm not sure that you could satisfy the court by just changing the shapes. You might have to change the movement also.
I think there's language in there where the court said there are a number of similarities and not one thing really makes it, but the fact that the defendant, if you're thinking of the Tetris versus CL case?
Zio, I assume is how it's pronounced.
Then it's one would consider that to be a Tetris clone, not necessarily even a Tetris derivative, but a Tetris clone. So maybe somewhere in there it's a slippery slope. It's a matter of degree.
Well,
right?
the court did say the style, design, shape, and movement of the pieces are expression. They are not part of the ideas, rules, or functions of the game. I think to the extent we're talking about the design, shape, and movement of the pieces, that simply isn't true. Now, I realize that in some cases it may be tougher to say what it means to be playing a particular game. Tetris is fairly simple, but if we were talking about a game like Dungeons and Dragons, there's so many rules in that game, and any particular group of people playing it are likely to modify rules, ignore rules they don't like, and yet we could still plausibly say they're playing Dungeons and Dragons. So I agree, at some point it may be hard to decide exactly what it means to be playing the same game, but with a game like Tetris that is fairly simple, I think the court is ultimately protecting the gameplay mechanics and requiring somebody who wants to make a game inspired by Tetris to do something very different. The designers of Tetris could have gone the patent route, but I think what the Tetris case says is, well, you can also go the copyright route, at least if we're talking about a video game. And that's likely because the courts view these as analogous to films, and they discount the role of the gameplay process. And to the extent they're willing to say gameplay processes are not protectable, they equate process to idea and say it has to be at a high level of abstraction before we say it isn't protectable.
And I think given the number of Tetris, I think Tetris began as a game, right? But it has since evolved into a genre where there are many, mobile games or even casual games involving things falling from the top and having to be laid in a certain pattern, right? And some of which went on to be, quite popular and well known as well. So I think that the court's expensive language in that particular case, Tetris versus ZL, would have to be couched in some of these commercial realities where even though it seems that the court is willing to give Tetris considerable copyright protection and include many elements under the rubrics of expression, the reality is that perhaps in a different case involving more of a Tetris-inspired game, such as Dr. Wario, Puyo Puyo, Super Puzzle Fighter, if you have you, then
Those are real games?
those are real games involving things falling from the ceiling and disappearing, right? Lines blowing up, right? Where a court may say, okay, this is quite far from where Tetris is, and I'll be curious to read about.
Yeah, as long as the visual depiction changes a lot, you might be safe. But in simple games, where there's not much more than a simple mechanic that's in play, I think courts have been willing to put those mechanics under the heading of copyright protection. But you're right. Despite what Tetris says about protecting movement, if it looked very different visually, the court might say, well, this is not infringing. You've changed the look of it enough.
Or even having some mechanic change, even if it incorporates much of what was in Tetris. I think if they're willing to make some rule change so that it's no longer just Tetris, the exact game rules, then they would probably survive infringement.
Well, we're out of time. Ben, I want to thank you very much for joining me and having this discussion about patents and a little bit about copyright as well. Thank you very much.
Thank you very much.